Hey, everybody. Welcome to Thursday night. Hey, everybody. John Skiba here from the Consumer Warrior YouTube channel. I am back after a couple week hiatus. I was gone out of town. I'll talk a little bit more about that in a bit. But here at the Consumer Warrior YouTube channel, what I do, I am an attorney in the state of Arizona. I do bankruptcy, consumer bankruptcy, and I represent people who are being sued by debt collectors. So we deal with all types of consumer debt type issues. And if you are a subscriber to the channel, and if you're not, you should be. So go ahead and subscribe. But each every week, every Thursday night, for the most part, I am here doing a live Q&A, just questions and answers, and pointing you to some different resources, strategies, things like that that you can use to help yourself if you're dealing with serious debt problems, and particularly if you're dealing with debt collection lawsuits where creditors are actually suing you, garnishing your wages, or if you're looking at options like bankruptcy. We talk about those types of things. So the way that I do it is if you're on YouTube, you can put your question in the chat section. I will put it up here on the screen and we'll go ahead and discuss it. As my disclaimer each and every week, I can't give legal advice, particularly because I'm not licensed to practice anywhere else except the state of Arizona. And anyways, you shouldn't be taking legal advice from some guy on YouTube anyway. If you have a real legal problem and you're in the state of Arizona, I do free consultations. My contact information is below. You can reach out to my office and talk to me directly. And I do almost all the consultations here at my office when it comes to this type of work. So we can talk directly. Or if you're in a different state, I'd recommend you contact an attorney in your state. I cannot do consultations outside the state of Arizona. I just try to make that known because of the whole licensing issue, and I don't know the laws everywhere else. So I get a fair amount of phone calls to my office where people want to set those up, and unfortunately I can't do that unless you're actually in Arizona or you have an Arizona case. So I was gone the last 2 weeks. I wasn't here on Thursday night. I didn't announce it ahead of time. I should have. But once, sometimes twice a year, my family takes a vacation. I tried to take a vacation and get away. It seems like we end up working part of the vacation. But I go to one of my favorite places on earth, and that is Lake Powell, the Glen Canyon area. I have a quick little video I want to show you guys. My wife took as we were hiking up to a place called Rainbow Bridge. This is me hiking. This is me without a suit. So you can see Rainbow Bridge here. It is one of the world's largest natural bridges. So pretty cool place. If you're familiar with the Glen Canyon area at all, Lake Powell actually looks like this. It's actually, I always say it looks like the Grand Canyon is full of water. It's a reservoir where there's a dam on the Colorado River. This is just above Lake Mead and Hoover Dam. But it's a really beautiful place. And so that's where I was for the last week. But we're back in the saddle, back doing this thing again. So if you have questions, go ahead and put them in the thing, and we'll go ahead and throw them up on the screen. And let's see here. Okay, let's see what Monterey says. When compelled to arbitrate, have you ever seen LVMV pay the arbitration fee and move forward with the debt under $5,000? So the questions on here as it relates to compelling private arbitration. So the background with this is if you are sued by a debt collector, whether it's like a credit card company or a junk debt buyer like Portfolio Recovery, Midland Funding, LVNV, Resurgent Capital, or even regular, American Express, Capital One, Discover, whoever it is, one of your options is usually in the terms and conditions of the original credit card. It will have an arbitration clause, and you can take the case out of court and put it into the private arbitration process through something like AAA, American Arbitration Association, or JAMS. And there's multiple benefits for doing that. Sometimes just getting it out of the court system. A lot of these courts, like in Arizona where I practice, they other than like your typical like criminal docket and tickets, speeding tickets and things like that, these junk debt buyer cases just clog the courts. And most of them go to a default. The courts get used to just kind of rubber stamping these things through. So there can be some benefit just to getting it out of the court and getting a fresh set of eyes on it. Also, it's often, and this goes to your question specifically, often the junk debt buyers in particular don't want to litigate in private arbitration because the filing fees are very high. Now, arbitration is different in that it's a private company, so they set their own rules, and the filing fees in a consumer case are much higher for the creditor than they are the consumer. So, for example, at AAA, the filing fee for a consumer is about $200. For a creditor like LBNV come in, they're going to have to pay out of pocket right around $2,500 to $3,500 just to get the case filed. Not only that, many of the arbitration clauses actually will have a clause in that says if you ask them, they have to pay your fee too. So to your question, have I ever seen them essentially follow me into arbitration? No, I haven't. They don't want to be there. And part of that may be the area I practice, in the state I practice, the attorneys that are practicing here, my case selection for cases that I choose to compel into arbitration. But if it's under $5,000, I think the chances are very low. The reason being that, like I said, they're going to be paying $3,000 to do it, particularly LBNB, who's a junk debt buyer. Highly unlikely as far as, that they're going to follow you, and they're not going to pay that amount with the chance that, if they lose, and often those fees can't even be collected in arbitration. So long answer there, but typically the answer is no. All right, let's see what Travis has to say. What happens when you offer a settlement and they come back with a number higher than the amount originally asked? In legal circles, that's what we call negotiating in bad faith. If they come in and say, 5,000, and you say no, 3,000, and then they say no, 6,000, they start going up. I always, when I have another attorney do that to me, I often will respond to them saying, hey, did you mean to go up? Because that's higher than your last offer. And it kind of shines a light on the fact that either one, they're going to tell me what change in circumstance would make them go up, or two, sometimes it is a mistake. So if they come back with a number higher than the amount originally asked, in order to negotiate effectively in settlement, you've got to position either the case or yourself in somewhere where you have a little bit of leverage. And one of the little kind of twisting points you have is you've got to be willing to walk away from negotiations. If they're being ridiculous, if they come back with something stupid like that, where they're at 5, you're at 3, and then they jump up to 9, of saying, yeah, we'll just litigate this. Or, at the end of the day, what I always say, they want to get money from you. And if you're offering money, there's got to be some kind of middle ground that can be reached. These places, they don't want to litigate. That's very inefficient for them. If you can get money to them, you should be able to get something in place. All right, let's see right here. I'm looking to file Chapter 7 or Chapter 13 when I move to Arizona. You can check, like I said, check my information below. My staff can set up a consultation, and I'm happy to talk to you. One thing to know about bankruptcy, you have to have lived in the state. The law says you have to have lived in the state where you file the better part of 180 days. That means at least 91 days after you've lived in the state of Arizona, you can file here. So you've got to have lived in Arizona for 91 days, but we can at least talk and kind of start putting that all together. So, all right, let's see here. Rini, I saw this. Yep, I was out last week, so I'm sorry about that. If you want to, I think you have my email address, or give my office a call and we can get something on the calendar. Appreciate you reaching out. Let's see here. This one says, I had a family emergency and I just missed a court deadline by 2 days for proof of service on plaintiff for a motion to vacate judgment. The hearing's in 2 weeks. Can I request an extension? Yes, you should always request an extension. Even if you miss a deadline, you should file a request for an extension and ask for the court essentially to forgive that. Doesn't mean that the court's always going to grant it, but the worst thing you can do, whether really any time in litigation, is just to not respond, to not provide some type of correspondence or communication with the court. So yes, absolutely, I would do that. So, all right, let's see here. Lyle says, I settled with Capital One, but they're telling me that they can't do a pay for deletion. I have to ask Capital One. Okay, so the background of this, we deal with this quite a bit when it comes to debt settlement, whether it's in a lawsuit or not in a lawsuit, is getting them to delete. That you agreed as part of the settlement that they're going to delete the line from your credit report altogether. Now, often we get pushback from creditors and from their lawyers, and they will say one thing they'll say, Lyle's like what's happening here. They may say if it's a debt buyer, they may say, hey, we don't control Capital One, which is true, they don't, and you'd have to reach out to Capital One to do it. But even sometimes when you're dealing directly with the creditor, they'll give you some pushback and they're going to say, hey, we can't do it. And their reasoning for that is, at least what they'll say, is that there's this law called the Fair Credit Reporting Act, the FCRA. The FCRA states that if a creditor or provider of information is going to report on your credit report, they've got to report accurately. And so sometimes they'll say, hey, look, we've got to report accurately, so we're going to report that it was settled. We'll zero it out. There'll be a notation on there that was settled for less than the amount owed. However, my response to that, and that is true, but my response to that is that there's no requirement that any of these creditors report, period, to the credit reporting agencies. They don't have to do it. They choose to do this and participate in it. But sometimes, particularly when you're dealing with a large credit card company, they have policies and they may or may not agree to it. My advice generally for people is if it's going to hold up a settlement, it's better just to get it settled rather than worry about the whole credit reporting issue, unless there's some kind of side issue that you're dealing with. So I would press for it, and I would just go back. If they come back and say, hey, we have to report under the Fair Credit Reporting Act, you can come back to them and say, it doesn't require you to report, period, and see if you can get some kind of, pushback there. So, all right. Jay says, big fan. You definitely gave me the courage to start Chapter 7 in California. Awesome. I mean, it's not awesome yet you're in bankruptcy. I always say no one wants to file for bankruptcy, but I think what a lot of people find out is that it's not as bad as they anticipate. It's generally, particularly Chapter 7 is a fairly straightforward process. In most cases, you don't lose anything and you recover from it much more quickly. Most people recover in about 18 to 24 months after filing. So glad you're able to do that. Let's see here. If a judgment against me is still being litigated through other means, Consumer Financial Protection Bureau, breach of contract suit, etc., is that reason to request a stay on the current judgment? If a judgment has already been entered, it is possible to ask the court to stay enforcement of the judgment so that they can't do things like garnishment or bank levy. In Arizona, at least under our rules, you usually have to post a bond with the court. And in Arizona, it's actually a cash bond that you have to post. So if they have a $5,000 judgment against you, you have to post a bond that's going to cost you $5,000 with the court. And then what happens is if you're successful on whether it's an appeal or whether something else is going on, then you'll get that money back. If you're unsuccessful, they just give it to the creditor. So I generally, when we appeal, I generally don't do that. But with an appeal and things like that, I generally don't see creditors do a lot of collections while stuff like that is pending, because if they happen to lose, then they're in a situation where they have to refund the money immediately, and kind of makes things difficult. So, all right, let's see here. Bankruptcy is a wipeout of all the debtor's debt, right? For the most part. Now, I always say not all debt is created equal, so it's a good question. There are certain debts that don't go away, like secured debts. Secured debts has anything with collateral or property attached to it, like a car loan, home loan. Those debts are not eliminated if you want to keep the house or if you want to keep the car or the motorcycle or whatever it is. There's no free house, no free cars in bankruptcy. You still have to continue to pay on those. However, I have had clients who want to, like, they have a vehicle they think is just way too expensive, so they will surrender it through the bankruptcy, and then they don't owe anything on it. But if you want to keep your car, you got to keep making the payment, and that debt will be there after a Chapter 7. There's other types of debts, what we call domestic support obligations, child support, spousal support, alimony, that kind of thing. Those debts are not eliminated in bankruptcy. You'd have to continue to pay on those. Some taxes. If the tax debt is 3 years, if it's more than 3 years old, often it can be eliminated, but otherwise tax debt would not go away through bankruptcy, and most student loans don't go away through bankruptcy. So that's, but everything else, credit cards, medical bills, personal loans, those kind of things, they do go away completely. They're discharged. There's no legal obligation on them going forward, and there's nothing that they can do to try to collect on them. So, all right. Monterey here again says, if a junk debt buyer offers to settle for 20%, do you generally take it or go for a full victory? This is a good question, because really what you're asking is, you have to determine for yourself what a win is. Obviously going to trial and getting a judgment in your favor and having them reimburse all your court costs, that's a big win. However, anytime you're in court and anytime you go to trial, no matter how good your case is, no matter how friendly the judge is, no matter whatever, there's always a risk that you could lose. And so that's what you kind of have to weigh is it worth it to go to end this? If you're representing yourself, if you've been doing this yourself, you understand it takes over your life. It's very stressful. There's a lot of anxiety. It's like your second job. You get home at night and then you have to do research and watch YouTube videos, that kind of stuff. So I can tell you 20%, even on a debt buyer, I usually recommend a client takes it. It's not a bad settlement offer. You're getting sued for 10 grand and you can settle the whole thing for 2,000. That to me, there's this scale that I look at where eventually the risk is too high to go to trial. Even if I think the case is perfect and I'm going to have a great chance of winning, if you get down 20, 15, 10%, take it and move on. And particularly if you're in a situation you can do it, I recommend you do it. So, all right. Travis family says, can you file a motion for dismissal in justice court in Arizona for medical debt that I don't believe I owe? I'm being harassed by $800, for $800 by Faber and Brand. It's a good question. So procedurally, what you would do if they have, it's crazy. They filed a lawsuit for $800. Those things always kind of blow my mind, particularly medical debt. We don't see that a lot because just to file it, depending on the court you're in, they had to pay probably almost $100 in a filing fee. They probably paid another $200 to have it served on you. And they may or may not even be able to collect on that. So a motion to dismiss procedurally is not what you would do. What you would probably do is a motion for summary judgment. So a motion to dismiss is if you're saying there's something defective in the actual procedure or the pleading, the complaint that they submitted. Like if they sued the wrong person, if they don't have jurisdiction, that kind of thing. But if it's something where you feel like I just don't owe this or I've already paid it, then it would be a motion for summary judgment that you could file with the court. And then they'd have to respond to it. And if you prevail there, then it's over. The court will enter judgment in your favor and it will be done. So that would be the process for doing it. In Arizona, anything under $3,000, unless Faber and Brand has an attorney, they're typically even held in the small claims court and you should get a hearing on it pretty quick. So let's see here. So it says from Laura says, if I'm a low income household and receive public assistance, would that be an exemption for the debt collectors in a lawsuit? So how the exemptions work, first of all, they're very state specific. Each state has their own set of exemptions and dollar amounts. So for example, like the Homestead exemption that protects your home in Arizona, it protects up to $400,000 of equity. However, I know like in Texas and in Florida, they have an unlimited homestead exemption. Nevada, it's like $600,000. But then I think it was like Kentucky or somewhere where I read it was crazy. It was like $20,000. And so it varies from state to state. The fact that you receive public assistance, those funds may be exempt. It's just like Social Security, retirement, Social Security disability. Those funds are generally exempt in federal and state law. So the debt collector could still file a lawsuit against you regardless of your income situation. The question is, would they ever be able to take anything from you? And if your income is protected, and I don't know if it is, it depends on the state and what kind of public assistance you're receiving. If they get a judgment against you, they may not be able to collect on it. So anybody can file a lawsuit over anything. The real key is collection. So, all right, let's see here. So it says, Janice says, junk debt buyer suing me for $20,800. I am judgment proof. Don't own my mobile home. My car is 24 years old, no savings, only Social Security. I'm going pro per. Janice looks like going for. Looks like there's a. This is, I have a video up on my channel. It's called the Do Nothing Approach to Defending a Debt Collection Lawsuit. And there are certain situations, it's rare, where I recommend people do not, at least you have the option of doing nothing. And it kind of goes back to that last question about, they can sue you, they can get a judgment, but if they get a judgment, can they collect on it? And the only little caveat I have to that, because like in this situation with Janice, Social Security, it's exempt. They can't garnish it, can't take it out of a bank account. There's no real estate to lien. The car, there's likely a vehicle, like in Arizona, the vehicle exemption is $15,000 of equity. And so it is. It sounds like you probably are judgment proof. The only little asterisk I put on all of this is you need to understand how long a judgment's good for, and if you anticipate your situation will change. Because while you may be judgment proof today, what about 5 years from now? What about 10 years from now? So, for example, in Arizona, a civil judgment is good for 10 years, and then the creditor can renew it for an additional 10 years for the rest of your life. They can just keep renewing it every 10 years. And so if it's something where you're like, hey, my situation is, it's not going to change, maybe that's an option. It's something I would recommend you talk to an attorney about. But if it's something where, okay, you're unemployed now, your asset situation is really low now, but you're hoping that it's going to change in 5 years, or you're a college student and you're hoping in 10 years from now things are going to be better. I'd be really careful about just letting something go to a default, because that could cause some issues there. So, all right. How does Florida get an unlimited exemption? It's based on legislature, local government comes up with those statutes. It's not federal. And so that is why, I don't know if this is controversial or not. Sometimes you see people who have large judgments against them. They will pick states to live in, like Florida, like Texas, that don't have any limit. O.J. Simpson, for a long time, lived in Florida because it had an unlimited homestead exemption. And so he had a civil judgment against him because remember, he got sued civilly for the murders. And by living in Florida, they couldn't do anything with it because there was an unlimited homestead. And I believe he lives in Nevada now, and Nevada has a $600,000 homestead exemption. And so it's just one of those things. You'll see people will choose the states they live in based upon exemptions. And what's interesting is in the bankruptcy code, they actually have a provision in there. This was one of the changes they made back in 2005, is that you have to live in a state for at least 2 years prior to the filing of your bankruptcy if you want to use that state's exemptions. So I couldn't move to Texas or move to Florida and immediately claim their homestead exemption in bankruptcy. I would have to use Arizona's homestead exemption until I'd lived there for 2 years. Same applies to people who recently moved to Arizona. I have to use, unless they've lived here at least 2 years, I have to use the exemption statutes from the state that they came from. So something kind of a unique little thing there. All right. Janice says, pretrial conference, what do I need to do? In most jurisdictions, the pretrial conference is a pretty quick thing. In Arizona, if you're in the Superior Court, it's with a judge. And really, they're just going to go over deadlines. They're going to probably set a trial date, may give you some dates for doing discovery and exchanging documents. In Arizona, it's done almost always through like a Zoom or a telephone conference. In our justice court system, the parties usually do it just amongst themselves and fill out a little report. So it's one of those things that's not a huge deal, but it's also something if you don't show up to can cause you some big problems. So I'd recommend you be there. So Lucy says, is there a procedure the creditor must follow to renew the judgment at 10 years? So the 10 years is Arizona specific. I mean, there's other states that have 10-year judgments limitations period. But for Arizona, it's 10 years, and it's also a state statute. In Arizona, what the process is they have to file what's called an affidavit of renewal with the court that issued the judgment. And what's interesting about it is they have to do it within the 90 days before the judgment is actually, before it expires. So it's not like they can get a judgment and then just immediately renew it. They have to wait the full 10 years. And then in the 90 days right before it expires, they have to file this affidavit of renewal with the court. If they do it too soon, if they file it 120 days before it expires, it's no good. Or if they wait until after it expires, it's no good. There's a 90-day window right before the expiration where they have to submit it with the court. So, all right. This one says, Arizona resident here. When filing a Chapter 7, do I have to include all credit card debts, or can I keep some of them? When the time comes, I'll be calling you guys. Awesome. Thank you. Okay. So this is a good question. I get this question a lot. The answer is yes. You have to disclose all of your debts. So in the bankruptcy filing, there are what are called the schedules. These are, and they're A through J. And each schedule, like A deals with real estate, Schedule B deals with personal property, C is the exemptions, and then we get into your creditors, Schedules D, E, and F. Schedule D is where we list all your creditors that are secured with collateral, like car loans, home loans. Schedule E is where we list debts that deal with like the IRS or domestic support obligations like child support or spousal support. And then E is kind of just everybody else, or I'm sorry, F. That's where we list what we call the general unsecureds, credit cards, medical bills, personal loans. You are required to disclose all of those debts. Like I said before, not all of those debts are treated the same. And as far as to your question, can you keep credit cards? I'll have people who say, hey, I want to keep a credit card, because I have to travel or for work or whatever. I tell people generally, just you should not plan on it. Even if you were to not include a credit card in the filing, they will get notice through the court's electronic noticing center, and they'll cut the card. Filing bankruptcy is an act of default, even if you're current on it, even if it's a zero balance. Credit cards, for good or for bad, you'll see if you file bankruptcy, your mailbox is going to get blown up with advertisements for credit cards and car loans right after you file. It is possible to have a credit card afterwards. You got to be really careful, obviously, but it is something that you can get. But you should plan on one, disclosing all of your debts, and two, that all credit cards will be terminated when you file the case. So, Janice had another good one. Can a bankruptcy clear a judgment? Yes. So particularly in a situation, Janice, like you were saying, you don't own any real estate. It's an unsecured debt and it will be eliminated. And even if you do own real estate and they've recorded it and that judgment is acting as a lien, in most bankruptcy proceedings, we can file a motion to avoid the lien and get that cleared out as well. So let's see here. Got a few more. I try to find things that are pretty general. It's also, I need to get someone to help me one day. So, let me talk with Rini. I know, Rini, you're part of our Consumer Warrior community. And those who, by the way, I put a link at the top in YouTube in the chat section. I have the Consumer Warrior University, as well as all of our templates and tutorials. Go check those out if you're representing yourself. There's a lot of really powerful tools that'll help you, they're tutorials where I teach you and give you some forms and templates on how to do a lot of the stuff we talk about here. And I know that Rini's part of that, and it had just talked about appealing her judgment. So it says the clock hasn't started ticking on the 14 days. In Arizona, you have 14 days in justice court to appeal. But when it does, I would need to be ready. If that happens and I can't get this settled, what are the odds of winning an appeal? This is a good question about appeals and what they are and what they are not. When you appeal a case, a civil case like this, so in Arizona, if it's a justice court, you appeal it to the superior court. If it's a superior court case, it gets appealed to the Court of Appeals. What the judges do is what they're looking at is they're looking to see, did the court abuse their discretion? So, and I had an appeal once just recently where we got a ruling back. I should say this, one thing it is not is they don't redo the trial. It isn't where you appeal it to the higher judge and then the judge just does a new trial and then makes a decision. They don't do that. What they do is they look through the documents, the transcript, the records, the recordings, and they look to see, did the judge make a mistake? Did the judge rule on something legally and it shouldn't have gone that way? Did the judge not follow the law? Was there not sufficient evidence to support the judgment that was entered? And what's interesting is I've had judges write this in opinions. I've had a judge say, look, I may not have ruled this way if I were the trial judge, but it isn't so far outside the realm of what's possible or what's not possible, but so far outside the realm of, the discretion that each judge has that we're just going to let it stand. And so that's what you need to look at is, and also, if there weren't appropriate objections made at trial, it's possible that you waive those on appeal. So deciding whether to appeal a case or not is something that, again, I would consult with an attorney and, looking at the totality of it. Sometimes there are some really good reasons to, but often I have people who will say, hey, they think they're going to get a new trial and they're not. They're just going to get a judge to look at and see if they made a mistake. So, all right. I think we will call it a day for that. But hey, it's good to be back talking to everybody. Go ahead and put questions in there. I do try to pull the comments up. If you're needing more help, go into our Consumer Warrior University or look at some of those templates up there. They're a big help. And other than that, we'll catch you next week. Talk to you later.